All right, we are here with Lance Stewart of Angus and Terry for our monthly CMU, and I believe the topic today is going to be about small claims.
Yes, it is. Thanks so much for having us, guys. It's always a pleasure to be here. For those of you who don't know me, again, I'm Lance Stewart. I'm a partner with Angus and Terry. We're a law firm. We represent HOAs throughout California, as well as Florida and Ohio. We've been providing really just about every form of legal services that HOAs need for about 35 years now, and representing HOAs is all we do. We don't believe that good help should be hard to find, or that having good legal help should be a luxury for HOAs. HOAs are corporations, board members are volunteers, they need help, and too often board members feel like they can't do what they need to from a legal standpoint because it costs too much. We want to make sure both you and they are getting the help that they need. So with that in mind, anytime we take on new clients, we provide two things. One is for the first 6 months, we reduce our hourly billing rate, no matter which attorney is handling the file, to $350 an hour. And for HOAs that are maybe kind of a mess when you guys get them, this can be a good way to get them straightened out while easing the financial strain on them. We also provide a complimentary 1-hour board legal training, which I think most of you know we consider an essential piece for arming boards with the information they need to be able to do the job they've taken on. If you need a proposal, if you need legal help, if you have a question, please don't hesitate to reach out. We're here. We've got Julie Mauser's cell phone and email address up on the screen. You can reach out to me, you can reach out to Ann, you can reach out to Ivy, you can reach out to Colin. Please don't be shy if you need help with things. The presentation itself, of course, is not legal advice. It's a general informational summary of certain considerations for HOAs. If one of your HOAs is a current client, of course, feel free to reach out to us for specific analysis of what they need. Or if you have an HOA that needs help, that needs counsel, feel free to reach out to us as well. A big reason why we don't like to circulate these presentations is that laws change all the time, and we don't want folks relying on outdated information. I imagine Melanie's going to ask me to pass this presentation on to you guys. Please just don't pass it anywhere else. Okay. So yeah, we're here today to talk about small claims matters. Anytime we give you guys advice or give your boards advice, what we're really thinking about is sort of that eternal question, could this end up in court? And thinking about things like, if it does end up in court, what exactly is that going to look like? Who's going to be on what side of things? What's going to be at stake? What's the exposure to the HOA? How bad could it get for the HOA? And usually when we're forecasting that scenario, we're thinking about sort of the big courts, Superior Court for the county where the HOA is located, or sometimes even federal court. The reality is, if the dollar amount at issue is less than $10,000, it's sometimes more likely that the situation will end up in court because it's much easier to get into court. And that's what we call small claims court. That's what we're going to be talking about today. I've got one right now for a fairly small amount of money where there's actually fairly little warning to the HOA before the homeowner went off and filed their lawsuit. The trade-off with these cases is that the exposure is going to be relatively small, but it's that much easier to get into court, and it's a little more confusing to know what to do when it comes up. So that's what we're going to be talking about today. Topics we're going to cover include the background of the small claims court system, the logistics of small claims case filing, the pre-hearing process, hearing preparation, attending the hearing, the post-hearing process, and the appeal process. So, the small claims court system was originated in the early 1960s. It's in the California Code of Civil Procedure. It's sections 116.210 to 116.950. This is designed to be sort of easy access to the courts. You've got a small claim, you've got a small dollar amount at issue, a low-level dispute. The legislature wants folks to go to this court, and it's designed to be a system where if you don't have a lot of legal knowledge, you can still navigate the system. It's not very costly. It's designed to be relatively fast, and it's designed to be... Are you guys still there?
Yes, we are.
The power just went out where I am.
We still got you.
You still got me?
Yes. You're just having a heck of a day, huh?
I really am. It's like flickering on and off. I'm in an office.
And you still have internet.
I still have internet. I'll be here for your amusement all day.
That's awesome.
And of course, I lost my notes.
Oh no.
Can't say anything without my notes. Give me just one split second to see if I can figure out what's going on. I'll be right back.
And I always thought they just did this at ad lib, but they actually have a whole script.
Okay. Nobody knows what's going on. I'm going to see if I can muddle through this. Thanks for your patience. So this is intended to be an easy process that's less formal than the Superior Court. Let's see if I can move on to the next slide. Okay. Types of things that might turn up in small claims. Generally, what we're talking about are dollar amounts. It is possible to go to small claims court and seek a court order, but really this type of court is designed for other things. It's designed mainly for monetary disputes. So property damage from a car accident, landlord-tenant disputes, damage to real property, disputes with contractors, collecting on monies owed. There can be a variety of HOA disputes that might come up, but again, typically what we're talking about is money, not so much, a homeowner claiming the HOA is failing to enforce the governing documents, or the HOA claiming somebody's in violation of the governing documents and trying to get an order to force them to do something. This isn't really the forum for that. This is mainly about monetary disputes. Who is the judge? Everybody still hear me okay?
We can hear you okay.
Cool, thank you. Realizing I also lost the handy light on my face. The judge in small claims court. This is another one of the weird aspects of small claims court. It's kind of a downside because in a very real sense, we're not really dealing with full-blown lifelong judges. It can be a commissioner, a temporary judge, or what's called a judge pro tem. It's a volunteer position. They complete a training program and they get to be a judge in this capacity. And usually what we're talking about is very general legal experience, somebody who's usually not functioning as a judge on a day-to-day basis, and certainly is not going to have a lot of experience with HOA law. We see some of that in Superior Court anyway, where our particular realm of the law is a little nuanced. It's a little bit of a niche area of law, and we always interact with judges who aren't quite sure what's going on, but that's even more so in small claims court, where there can be an X factor, where we've seen it happen that judges aren't quite as familiar with what's going on, don't quite have the same grounding in HOA issues, and sometimes take a hard left turn when they should have gone right. So that's one of the downsides to small claims court. Logistics. So this is a special division of the Superior Court. When we talk about who can sue and the amount which can be sought, I already said that usually we're talking, well, if you're an individual, this has to be a dollar amount of less than $10,000. If you've got a claim you want to bring for, and you're an individual, for $10,001, you've got to go somewhere else. Small claims court is capped for individuals at $10,000. What that means for an HOA is if somebody's suing the HOA in small claims court, the HOA isn't exposed for more than $10,000. It's going to be somewhere under that threshold. The HOA can also bring a small claims action if they believe that a homeowner owes them some money for something, but it has to be under $5,000 for the HOA to pursue that. You can only pursue, I have to do this off the top of my head. You can only pursue claims of $2,500 or more twice in any 12-month period. And anyone who's filing a lawsuit has to fill out a form saying under penalty of perjury that they have not filed more than 2 claims of more than $2,500 in the past year. For claims that are under $2,500, the fees vary. The filing fees vary depending on how much the dollar amount at stake is. What happens is, and I really wish I had my notes now. The case gets filed, and the clerk schedules it for a hearing. I believe it's to be between 20 and 70 days after the notice from the clerk goes out, telling everybody what that hearing date is. What that means for you guys is, if you get notice of a small claims action, you find out the HOA has been sued in small claims court, don't wait to tell the board, don't wait to tell council about it. We'll talk later on about the extent that we can be involved in a small claims action, because our role is limited. But obviously we're much more helpful if it's, we have 50 days before the hearing as opposed to 20 days or even less than that. So the moment you get that notice, make sure you're getting counsel involved. Okay, the process to get things going, whoever's filing the claim, whether it's the homeowner or the HOA, fills out a standardized form. You don't have to draft a great big formal legalistic lawsuit. It's very much a fill-in-the-blank form. What is the thing you're upset about? What's the dollar amount you're trying to get? Why do you think you're entitled to it? Bing, bang, boom. You file that with the court clerk. You pay a filing fee, and the court clerk sets up when the case is going to be heard. The complaint, the lawsuit, has to be served on the other side. If it's the HOA filing the lawsuit, you have to make sure it actually gets served on the defendant. If somebody's suing the HOA, they have to make sure the HOA gets properly sued so that you all have notice that the lawsuit is actually happening. And there's a lot of technicalities to what is and is not proper service. Usually the best bet is making sure that you've got a registered process server handling it, the professionals, so they know what to do and they can make sure they do it properly. You have to file a proof of service with the court, meaning there has to be proof that if it's a homeowner suing the HOA, that they actually filed notice of the action with the HOA, that the HOA received that notice from the plaintiff. If the HOA is filing a lawsuit, same thing. Pardon me, you have to file proof of service showing that the defendant was actually served with the lawsuit. Okay, this is really where we come in and be most useful to you guys, or counsel for the HOA can be most useful for you guys. You probably all know that by definition, attorneys can't appear in small claims court. You guys can. You as a representative of the HOA, the manager, can go and appear on behalf of the corporation in court. We can't physically be there because, attorneys make things really complicated, and part of the point of small claims court is to make things simpler. So there's no discovery process. There's not a lot of the rights that you ordinarily have in a lawsuit. It's meant to be very simple and straightforward, so no lawyers. But the law also expressly states that lawyers can help on the sidelines. And usually what that means for us is that we're working with you guys and your board before the hearing happens to figure out what is the case here. Just like we would in any other case, what is this person claiming, or what is the HOA claiming? And what's the flip side of that? What are the strengths and weaknesses in the HOA's position? If a homeowner is suing the HOA saying the HOA failed to maintain something and cost me some money, the HOA didn't comply with X and Y and Z, what's our response to that? What's the HOA's defense? What's the good thing? What are the good things? What are the bad things about the HOA's case? And the same thing if the HOA is suing a homeowner, suing somebody else in small claims court. We want to go through what the evidence is and figure out what the HOA's best case is. We cannot file a formal pleading, but we can draft a letter to the court, usually intended to be coming from the manager, from you guys, but putting all that information together and making the arguments that are appropriate to make. It's intended to be in your name on behalf of the HOA, but usually we're ghostwriting it, we're putting it together. So you have the various legal arguments, you have the various factual arguments. If there's documents that help explain why the HOA is in the right, we attach those documents to the letter. If there's invoices that are important, if there's photographs that are important, whatever pieces of paper help make the HOA's case, we want to attach that to the letter. So really what's happening is we're drafting the same arguments that we would make on behalf of the HOA if we could appear, but putting it in a format that's meant to not slow down this process, meant to let it proceed, but in a way where it can be coming from you guys and you can do what you need to do to stand in for the HOA. So we compile all the documents, we determine if there's weaknesses in the evidence, we draft a letter to the court introducing the judge to the HOA, explaining, I'm the manager for the HOA, this is an HOA that's located in Concord or Walnut Creek or Danville or whatever. It has so many homes, and this person is claiming X, and here's why we think they're in the wrong. They say we're responsible for damage that happened to their car. Here's why they're not. They say that we were supposed to do something under the governing documents. The governing documents actually say this. Here's why we're right and they're wrong. We provide the factual background, the legal authorities, attach copies of everything. And what we want to do is lodge that with the court prior to the hearing. There's nothing formally requiring this, but usually what we're shooting for is about 10 days before the hearing. And the reality of that is that, like I say, the judges in these matters are working on sort of a voluntary temporary basis, not voluntary, but they're working on a temporary basis. Odds are they're not going to see it. We want to have it with the court ahead of time so we can have taken that step. But we also have to assume that they haven't necessarily seen it or haven't had time to review it ahead of time. So the other piece of that is to arm you guys, if you're the ones appearing. And it doesn't have to be you, it can also be a board member, but whoever's appearing, arm that person with a copy of it, and actually 3 copies of this letter and all the documents, one for you or whoever's appearing, one to be handed to the other party, if it's the defendant or the plaintiff. Here's the HOA's response to what you have to say, and something that's going to be handed to a copy for the judge as well. And that way you have everything mapped out ahead of time. You have the documents all lined up and easy for the judge to go through and figure out what's going on. The other party knows what it is you're talking about. Everything is done in advance. The other thing that we do, and hopefully any other counsel you're working with does as well, is put together a trial outline. Not with all sort of the legalistic gobbledygook that we're so keen on using, but working with you or working with the board member to say, okay, here are the basic points. Here's what this person is claiming. Here's the HOA's response. You want to make sure the judge understands this and sees this piece of paper and sees this piece of paper. Boil it down as much as we possibly can in terms of what needs to happen in the hearing, and arming you or arming the board member with what it is they need to do during that hearing. So you get the full benefit of an attorney's involvement. We're not going to violate that part of the law that says we can't be there. Post-hearing process. Okay. If the HOA is the plaintiff, the HOA sued somebody, and the court has now said, HOA, you win, you get X amount of money. The next step is to send a demand letter to that person. If it's a homeowner or a vendor or whatever, the court ordered that you pay us X and Y and Z. You now are obligated to do so. We also want to make sure that you're working with the debtor to obtain payment. In other words, saying, whatever it is you need to do to get the money to us, we're to work with you to do that. You're going to record the judgment and understand that the defendant, if they're losing, can appeal the outcome. We'll talk more about that in a moment. If the HOA is a defendant, a homeowner has sued the HOA, a vendor has sued the HOA, and as the defendant, the HOA wins. In that context, the plaintiff does not have a right to appeal. Homeowner sues the HOA in small claims court, homeowner loses, the HOA wins, the homeowner cannot appeal that outcome. If the HOA loses as the plaintiff, same thing. If the HOA is suing somebody, suing a homeowner, suing a vendor, the HOA can't appeal that outcome. As the defendant, if you lose, you do have the right to appeal that outcome. I realize I just said the same thing a few different ways. The bottom line is, if the plaintiff wins, they can't appeal but the defendant can appeal. All right, the appeal process. There's a strict time limit of 30 days after the notice of entry of judgment is mailed out by the clerk. That's the document that's critical here. The clerk mails out a notice of entry of judgment saying the court ruled, this is what's happening. 30 days after that is the hard deadline. There's no extensions for any sort of appeal. Pardon me. And we've had these come up where there's an issue where the HOA is on the losing side of a case and we step in to handle the appeal. There's a strict time limit for that. We need to make sure it happens right away. What happens when there is an appeal is it then goes to Superior Court. Now, in practical terms, we've seen it where you sort of end up with somebody who isn't very different from the judge that you had the first time. It's not going to be the same judge. It can't be the same judge, but the idea of the appeal is that it's going from a small claims court to the big court. and that's who's going to determine whether the small claims court did something wrong. It's what's called a trial de novo, which means that judge on the appeal hears the facts all over again. We make the arguments all over again, and to see if there's going to be a different outcome. In this context, an attorney can be present, and like I say, we've done this. We've appeared on appeals of small claims matters. There's particular penalties that can come up if the court concludes that the appeal itself was frivolous, shouldn't have been brought in the first place, was being brought in bad faith, was being brought to keep the other side from collecting on what they were entitled to. There can be pretty stiff penalties for that. The court can award up to $1,000 in attorney's fees and can award up to $1,000 in transportation costs, lodging costs, and a couple of other things, just on the basis of the idea that the appeal shouldn't have been filed in the first place. That's in addition to whatever recovery the other side is supposed to get in the first place. So we want to make sure that if we're considering appealing a case, there's a good, strong reason for doing that. We don't want to be screwing around with that aspect of things. Okay. We talked about this somewhat already, but ways that we can be helpful. I would generally urge, sometimes the cost involved, the dollar amount in dispute is so low that it might not make sense to get us involved. If you're talking about, a couple $100s, maybe it doesn't make sense to have counsel involved. But once we get into a couple $1,000s, you very quickly reach a place where it makes sense to spend the time to have somebody assess the issues, figure out what arguments can and can't be made on behalf of the HOA, what facts are needed to support those arguments. But it's always a discussion you want to have with your board at some point soon after it's been filed. The HOA has been sued in this small claims action. The HOA is being sued for X dollar amount. We believe you should get your counsel involved to help you out. Counsel can't appear, but they can help you defend the HOA to the best of their ability. If there's a situation where the HOA is entitled to money for less than $5,000, there's a determination the board needs to make. Do we want to go to small claims court? And it's the same analysis that you always want boards to be making in terms of, is it worth the resources being devoted to get the case into court in the first place in order to recover what we're trying to recover? What's it going to cost to do this versus what we're trying to recover? But in situations where the HOA is legitimately entitled to a relatively small amount of money, it's a decision the board needs to make. Does it make sense to file a small claims action to get this money out of this homeowner, out of this vendor, whatever the case may be? Various statutes of limitations might apply. You don't want any situation where the HOA is considering suing somebody to sit around forever. And a year goes by and it turns out a year was the statute of limitations, or 2 years goes by and it turns out 2 years was the statute of limitations. You want to make sure that you're acting promptly on these things. You want to make sure that the service of the matter is handled properly. We can help with that. We've talked about reviewing the evidence and drafting correspondence to the court and preparing an outline and making sure that you or the board member or whoever's going to appear knows what it is they're doing once they get to court. What's the argument? Why are we here? And of course, if there's an appeal to be had, or an appeal is being had, you can't have counsel present for that. The law allows for that, and that's a decision the board needs to make as well, getting counsel involved. And certainly we would recommend, if there's an appeal, whether the HOA is pursuing the appeal or somebody is appealing a good outcome that the HOA had, we would recommend getting counsel involved. Okay. So that's the presentation. Is everybody still with me?
Yes, sir.
Yes.
Okay. Looks like the lights have gone on outside my office, but I don't have power yet. I feel like I always blaze through these presentations. They're meant to be relatively bite-sized presentations, relatively simple things that bear some fleshing out. But I always worry that I'm going through them too quickly. What questions do you guys have? What would you like to talk about?
So Lance, you had mentioned that when a small claims case is heard. It's a justice pro tem.
Mhm.
Is there an opportunity, and is it recommended to utilize that opportunity to request an actual justice to hear the case?
There's essentially a stipulation that the parties agree that it's going to be a judge pro tem, and you have the option of saying, no, we don't want to do that. The problem with that is going to be delays. It's going to drag the process out, and it's going to be a judgment call whether the HOA wants to do that.
Lance, I'm spending a lot of time in small claims court over this case and whatnot, plus all the time meeting with you and the board about it. How do I ask the judge for funds back if the case is found in our favor, in the HOA's favor?
If it's not in your favor?
If it's found in our favor, if we're defending and it's found in favor of the defense, how do we claim our fees back?
Give me 1 second here. Let me see if I can make my way to my notes.
Or is that even an option?
Part of what we're saying in any, hang on a second here. All right, what I'm going to do, because I'm not finding it at my fingertips right now, I'm going to put together a quick follow-up email about that particular question. So your question is, just so I have it correctly, the HOA gets sued.
Yes.
Wins, can the HOA get its costs back? And I don't remember off the top of my head how that works, but it should be relatively easy for me to find.
Perfect.
And
I just have
go ahead, Nancy.
just a quick question. Are you saying that these guys are not even lawyers?
No, they are lawyers. They are lawyers. They're not standard form judges. Okay. A lot of times they're lawyers who practice on a regular basis, and they've taken essentially a training program to stand in as a judge in these cases.
Okay, just wondering.
No, it's not like somebody's up there with no idea how to practice law. It's just that you don't get sort of the same weight and gravitas that you get with a Superior Court judge. And sometimes it can be a little frustrating for us to try to explain to somebody who doesn't exactly know what's going on how the law is supposed to work in this sort of unique set of circumstances.
Thanks.
Mm-hmm.
And I was just going to make a couple of comments about after you get a judgment. And I apologize if you mentioned this, but did you talk about abstract of judgment, tying it to all the properties a person may own? Yeah, you did.
Yeah.
And then also about if we do get a judgment, how that's a time where we can refer that over to the collection company. So it's not on the management company to actually collect. And the upside with a lot of these cases that you might take to court is that we should have banking information. So if we get a judgment in the favor of the association, levying a bank account or garnishing wages is some of the options that we can use to get that the money. So it's a great tactic of already having bank account information when we do get a judgment and collecting on that judgment.
Absolutely. Yeah, we did touch on that. You need an abstract of judgment, and you need to get a demand letter out to the person right away saying, we won. Where's our money?
And isn't that like 10 days? And then we can have them respond in writing to all those questions, the banking information?
You talking about a debtor's exam?
No, after you get the judgment, you get the file from the court. And then I believe the owner has like 10 days to respond with banking information. And if they don't, if we don't have it, we can go back to court and make them say that information, their financial information in front of the judge.
You might be thinking of something else, but I'll take a quick look at that and get you guys a follow-up email.
Okay. Yeah, a few years ago, I was probably in small claims at least once a week, once every couple of weeks. So it's been a couple of years, but that's what I remember for East Bay, Solano County.
You might be right about that. It's reminding me of a couple of different things, and I don't usually be, bopping around on the various resources that I have in my notes and giving you a quick answer, and I'm a little hamstrung at the moment.
Okay, no worries. It's not a test. And this isn't legal advice, right?
Yeah, it doesn't count anyway, right?
Does
Other
anyone else have any questions for Lance? All right. Well, thank you so much for your time today.
Absolutely. Great seeing you guys. Thanks for having me, and we'll see you again soon.
Thank you.
Thanks, guys. Bye.
Thank you.